Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public, so please subscribe to our channel. What is supervised visitation? What does it really mean? Let's define supervised visitation, when it comes about, and what you might do about it. Well, you have to understand, the general rule is that the court is going to try and maintain the same relationship with the child and parents as existed before this proceeding. So if the parents were just having a normal situation, normally family situation, where they parent together, sometimes the husband has to go to work, so the wife takes care of the child, sometimes the wife has to go to work, husband takes care of the child. If that's what was going on, the court won't see any reason to interrupt that kind of parenting time. Where the court requires a supervisor to be present in what we call supervised visitation is when there's something out of the ordinary happening. For example, the parents had a normal situation, but now one of them is addicted to drugs. The court might be concerned that if the person had the child in an unsupervised format, they put the child away, drive to go get drugs, and put the child in a dangerous situation. Maybe they're an alcoholic, and they're concerned they're going to drive the kid while under the influence. So in a circumstance like that, where the child might be in that way abused or even neglected, the court may order that the parenting time take place, but only under the supervisory, watchful eye of somebody appointed by the court to do that to protect the child. That's why the court orders supervised visitation in the first place. Now, it doesn't mean, by the way, if it's supervised, it'll be supervised forever. The court, for example, may find that a person is challenged with alcohol, and now they're in AA and they've been sober. The court might order supervised parenting time until the person, for example, graduates AA. Or until the court maybe orders the person to test for alcohol, and it's a negative test, a certain amount of tests, the court may lift the order of supervision. You have to understand that generally the orders of supervision aren't permanent. They are designed to address a circumstance where the court believes that failing to do so may in some way be dangerous to the child. Once the court, however, is satisfied that the condition that existed before that caused the supervision no longer exists, you can well expect that the court will lift that order of supervision. Not all spontaneously, to be sure. The court will not know that there's a reason to lift it unless someone files a motion. So the typical mechanism will be that the person under the supervision will file a motion before the court or have his lawyer file such motion, which would say that on such and such date the court ordered supervised visitation. The court did this for reasons A, B, and C. Reasons A, B, and C no longer exist, therefore the order of supervision should be lifted. That's generally how it goes. And expect, if that motion is true and those conditions are resolved, the court may very well lift the order of supervision. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.